Very warm welcome to all of you. Thank you for joining this session. We'll try to make it as interesting as we can and as interactive as we can. We have with us today Mr. Praveen Jain. He's a CIO with a family office, with a large family office. Along with me, along with my partner Pratik, will be presenting today. Before we get into the topic of the discussion today, I would want to do the ritual. We'll go through we will go through our firm and a bit of introduction about our firm. So Karishma, can you go to the slide? So this is our tax team. We have been able to develop a very strong corporate taxation team, and across all the major verticals along the corporate tax, including transfer pricing, poem advisory, and all. We are covering all the international taxation as well. Apart from corporate taxation, we as a team at MICS, we have a strong structuring team, licensing team, tax accounting compliance team, and corporate finance team. So, and audit as well. Now, recently we have taken audit license as well. So we are now becoming a full-fledged advisory firm in our space. Can you go to the next slide? Yeah. So these are the spectrum of advisory services that we cover at our firm. Usual disclosures. I mean, whatever advice that you take on this webinar is based on some generic thing that we are saying. Your specific case can be addressed on a very specific basis, and and you can take those advice separately on one-to-one basis with us. We have been doing this kind of webinars and seminars across various different topics on taxation, compliance, and other areas, structuring. And we continue to do this endeavor every on a very frequent periodic basis. And this is one of the latest initiative that we have. Going forward also, we'll continue to do that. If you have missed any of our webinars or seminars, we periodically publish it on our YouTube channel as well. So please feel free to watch those on our YouTube channel. Apart from that, our opinion articles are regularly being picked up by the leading newspapers. You can access those opinion articles across various domains of taxation and structuring. And these are the links of those. We'll be sharing this presentation at the post this seminar. Now, coming to this topic of today's discussion, we all know that UAE is a magnet for adventurers, fortune seekers, and of course, those elusive creators known as ultra high net worth individuals, UHNIs and HNIs, and their precious capital. Last few years, there has been an unprecedented flight of HNIs and UHNIs and their riches flocking to our shores and now calling UAE as their home. Now, let's face it, in the hustle and bustle of our everyday's life, who has the time to think about passing the torch to next generation? As one of my wise senior friend, a seasoned insurance professional, once beautifully summarized life as a journey through 5 stages: learn, earn, save, invest, and transfer. Picturize this life like a video game with above 5 levels. As we land on this beautiful planet called Earth, we start learning different language, learning to walk, all those things. Then we get into the earning phase, then we save, then we invest, and we transfer. And one of the key things is transferring, but it seems that most of us get a bit lost on various phases of life, forgetting about the critical aspect, which is the transfer part. And trust me, that's a huge mistake that we all do. And it's this quote from this slide, wherein Benjamin Franklin says only 2 things in life are certain, which is death and taxes. We have seen numerous family disputes exemplified by cases like Ambani, Singhanias, and Birlas from Indian families to Ford and Rothschild family from Western world, underscoring the need and importance of establishing a clearly defined structure for efficient transfer of family wealth and legacy during the lifespan of the so-called mukhyas of these families. All these mukhyas were extremely successful in their life. Think of the story of Dhirubhai Ambani, from petrol pump attendant to owning world's biggest oil refinery. Such a successful and wise man, and yet he failed to transfer his family wealth smoothly and efficiently to his two sons, leading to a very costly and messy dispute. Not only for his family suffered, this was also hurting to investors as well. These high profile cases, hence we all know about them. These are all the high profile cases, therefore we know about them. There are thousands of such other cases, including many within our known circles. In addition, let's not forget, protection from personal liabilities remains a pressing concern. Think of personal guarantees that bankers force you to sign at all time while borrowing, even the so-called limited liability companies. Given the expatriate nature of UAE, establishing efficient structure is paramount. We have encountered numerous clients seeking the best and most efficient means to manage family wealth, covering multiple facets such as efficient consolidation, seamless succession planning, tax optimization, trusted jurisdiction, safeguarding against personal liabilities. And it is often very difficult to identify one structure fitting all. Fortunately, the UAE, living up to its reputation, has been proactive in providing efficient framework or structures to reinforce its standing as a premier jurisdiction for wealthy families worldwide. For today, we will be delving into the details and nitty-gritties of one such structure called the foundation, which efficiently addresses both the certainties that you see on the slide, which is death and taxes. It is like a superhero amongst various other options UAE has to offer, like drafting a will, creating a holding company, or forming a trust. So buckle up, because we are about to embark on a wild ride through the world of tax-efficient succession planning UAE style. We are fortunate to have with us today, as I mentioned, Praveen Jain, a seasoned chartered accountant and a CFA charter holder. He's a CIO with a large family office, to share his views and expertise from the point of view of family offices on our panel. And before that, I request my colleague, CA Prateek Toshniwal, to delve into the basic overview and structure of a typical foundation. Over to you, Prateek.
Thank you so much, sir. I hope the introduction was so enriching that we understand that UAE has come up with a lot of important structures, not only just for asset protection, wealth management, but also, like it mentioned, that is succession planning. Foundation is one such structure. Foundation has become one of the most popular structures which a lot of ultra high net worth individuals, family offices, and GCC nationals are utilizing to make sure that today, that is the assets that they hold, and the tomorrow, which is going to be a succession planning, is taken care of. UAE introduced the foundation law, at least by DIFC, in 2018, and the first structure came into existence with the law DIFC Foundation Law 2018. And it gave a lot of facilities and lot of nitty-gritties to families to park their wealth and a flexibility. A lot of people are not very sure of declaring assets in their personal name, and privacy was very important topic which was covered by foundations itself, because foundations hold the asset and not the founder, and the assets are managed by the council, which is not like a shareholder structure, but it is like a council body that takes care of the assets around it. DIFC, ADGM, and RAC are the prominent jurisdictions where foundations can be actually made. But what are the nitty-gritties? What are the important concepts to understand is very important, and that will be covered by two panelists, Sheetal Soni and Praveen Jain, during the panel discussion. I would want to highlight few fascinating structures and features of foundation. It not only helps you in family wealth and succession planning, but also helps you in business and investment holdings. It can make your life easy when it comes to asset protections and arbitrations. It is a philanthropic initiative and make sure that a lot of charitable activities can be also done by foundations. So foundations are generally taken as a structure when someone wants to do a family office structure or a family asset management structure or charitable activities. Specifically, we will be covering jurisdiction regarding DIFC during our panel discussion. And DIFC Foundation law establishes a robust family governance structures, and it has followed a lot of leading jurisdictions like Netherlands, Liechtenstein, Jersey, and make sure that the law is airtight. When we take care of foundations, it also mentions about how the audited statements have to be annually filed. It makes sure that corporate tax in UAE has taken care of foundations, and a lot of foundations can be eligible for 0% corporate tax. Foundations have infinite lifespan. You can always define a life, but generally, if you do not want to, it can be held for infinite years. So giving this as a background and overview of foundation, I would delve into a panel discussion with Praveen ji and Sheetal sir. And before that, like Sheetal sir mentioned, Praveen ji comes with an enrichment and 20 years of experience when it comes to M&As, business valuations, family office managements, and he's also made global multiple asset class portfolios and has been heading a prominent single family office in UAE. He has been extensively involved in cross-border structuring of private wealth. And our very own Sheetal Soni, he has been in the region for more than 20 years, was the CFO and finance controllers with a lot of large GREs, has headed corporate finance during the last 8 years, and has a lot of experience when it comes to business valuations, structuring, and international structures. So before we go into the nitty-gritties, I would love to throw a generic question to Praveen ji, and then Sheetal sir can add wherever necessary. Why have there been a surge of foundations in UAE, and what do the basic foundation means and importance of the foundation? So over to you, Praveen ji, for a basic understanding of foundation.
Sure. Good evening, everyone. And thank you, Prateek ji and Sheetal ji, for inviting me here and sharing whatever is my practical experience of setting up the foundation at our family office. I'm happy to share what I've learned over the last 6 months while setting up our own family office. I think as we speak, there are more than 1,000 foundations which have been set up in UAE. And this has been over the last I think it has picked up pace from 2019 onwards, although the law came in place around 2018. And one of the reasons for its popularity is that, one, it provides a framework in our civil law jurisdiction, which is UAE. It provides a common law framework. Now, what is a civil law framework and a common law framework? A civil law framework is where the judges can decide on each case individually. There is no precedence which is applicable on them. Whereas in India, in UK, a common law jurisdiction is applicable, which means all the judgments of the courts get imputed into the law. They become part of the law. And this precedence gives a lot of certainty to the client. So with DIFC common law jurisdiction, it brings a lot of certainty. Generally, HNIs like a common law framework, and hence once the common law framework was put in place, people have been very comfortable in terms of structuring their wealth and putting it into a foundation. So what is a foundation? A foundation is fundamentally an independent legal entity which can hold assets separately from the founder's personal assets. So you can have two. One is the founder's personal assets. Once it's transferred into the foundation, it becomes a separate pot which is alienated from the founder. As I said, it's generally used in civil law jurisdiction. The common law jurisdiction generally is the trust law and the trust structures. Okay. Now, the unique feature of a foundation is that it functions like it's not hybrid between a company and a trust, but it has the features of both a company and a trust. Now, what I mean by that is that a trust is a contractual obligation between the settlor and the trustee. In a trust, generally, the trustee holds the assets for the benefit of the beneficiaries in the trustee's own name. In the case of a foundation, the foundation being an independent legal entity can hold the assets in its own individual name. So this gives a lot of comfort to the founders who are endowing or transferring the wealth into this structure. And from a succession planning perspective, one very important distinction between a company is a company would be having a shareholder on top, whereas a foundation does not have any ownership on top. Foundation will own the assets, it will have the defined beneficiaries. Hence, in the event of passing away or demise of the founder, or even if the founder gets incapacitated for whatever reason, there is no issue. The entire business, the assets can continue to function as is. So this is one unique feature of a foundation, which makes it very, very attractive from a structuring and a succession planning perspective.
Excellent, Praveenji. And if we can also dwell into the importance of a foundation in terms of, when we covered about asset protection. So what are the importance, why would such a foundation matter, and what are these importance of foundations? And Sheetal sir, if you want to add anything.
Yeah, see, as far as foundation is concerned, it's a separate legal entity. So as I was covering as I have covered in the introduction part as well, that, we end up giving, personal guarantees in our capacity. And these kind of things get protected. And also, particularly when it comes to, DIFC Foundation does not accept any legal, proceedings or judgments that are being recognized in other jurisdictions, right? In the name of a person. So or the founder. So the foundation ensures and guarantees shielding of personal liabilities against the assets that have been transferred to the foundation. So that is one of the key and notable thing that trust also do, but foundation does it. There are, other structures as well, which we will cover, later on. But this is the main fundamental, point from the point of view of liability.
Excellent. Yeah, Praveen.
So I will be covering and adding on to what Sheetal just said. The first is protection of family assets and heirlooms. So what do we mean by that? Typically, a HNI would be creating his wealth through any enterprise or a business venture. Business venture inherently is risky. It entails, having various liabilities, either in terms of creditors, or it could be any other form of liability also, which could get attached to the business. If the business is held in the individual name, or even if the shares of the company are held in an individual name, while the company would provide one level of protection of a limited liability, still personal guarantees get signed, one. Two, not just that, you would be having a situation in a family where there are, nowadays, all the HNIs are generally global families. They would be having passports in multiple jurisdictions, and they would be married with and the spouses would be across multiple jurisdictions. So a protection of a family is not just a creditor action. It could also be if there's a divorce in the family. Then what happens? Okay, will the assets go half and half to the spouse? Okay, what happens if there are adopted children in the family? So there are a lot of complications which come in, which play on the mind of the patriarch. And how does he protect the assets? He can ring fence his assets by putting it into a foundation. It gets protected from any kind of government action, any kind of dictator action, banker action, even things as simple as a divorce, or in the case of any family member were to pass away, then if that particular individual family member has married in a jurisdiction which gives the spouse a right over the assets, which the founder may not want to pass. So a founder may want his entire wealth to be in his own bloodline. He would not want to, while the spouse may get some living allowance, the spouse may not want, he may not want the spouse to become the owner of the assets which the family patriarch or matriarch has built. So this is one a very important area where the family, where the foundation provides the protection. From a succession planning perspective, what happens is if you look at a will or any other way of succession planning, the assets can go in absolute terms. A founder will typically have one concern on his mind that he has spent about 30 years, 40 years, 50 years to build his entire wealth. And generally, what happens is there is a Chinese saying, right? Short leaves to short leaves in 3 generations. A lot of wealth gets squandered away, a lot of wealth just get wasted away. What the founder wants to do is he wants his next generation to enjoy the income, but not necessarily be able to sell the assets. So this is the mechanism in which he can put the provisions in the foundation, in the charter and the bylaw, whereby he can say that the family members are entitled to the income. They can enjoy the income, but they cannot necessarily, so that he can put whatever restrictions he would want to do. That is one. Second is something which is very simple. The founder may have a concern that if he were to pass away and if his children are still young, let's say if they're at about 20 years of age, they still do not have the maturity to handle such a large fortune. He may have a provision that the foundation can pass the assets at certain milestones that the individual reaches in his lifetime. It could be either age, it could be either marriage, etc. And likely he can ensure that there is a phased transfer of assets as opposed to just giving it away. So all of these things can be structured in a family foundation, which makes it attractive. From a family governance perspective, what happens is that you can define, if you've got a family business, you can then define that the ownership remains with the family foundation. As per the charter, the family foundation can have control and can appoint the directors and can manage all of the family governance matters. But the privacy for the beneficiaries is there because it's not a public document. The beneficiaries can continue to enjoy the wealth without their names being public. And finally, every HNI would want to give back to the society. So they typically set up a family foundation, which is a very effective vehicle for giving away their wealth and to manage all of their philanthropic activities. So these are the various importance of the foundation. One more thing I would like to add is one major concern or challenge which HNIs have, and I've been fortunate enough to speak to multiple HNIs. One common thing that I find is that they've always built their wealth by being in control. Okay? They have their sense of self-worth coming in from the business. It's very difficult for them to let go of that. For them, the moment they transfer it to a trust or to any other structure, or if they give it away to the next generation while they are alive, they feel that they are giving up their entire control and their sense of self-worth, which makes it very difficult for them to give up control. In a foundation, they have the flexibility of managing the affairs of the foundation as they deem fit as long as they are alive. After that, they can do it through the letter of wishes and the bylaws. So this is one area where they get a lot of comfort that once they've devolved the assets into the foundation, they can still have a reasonable amount of control. Something as simple as the charter can define that the beneficiaries, the distribution will be decided by the council member and the council will be appointed by the founder. So the founder can decide that let's say there are 10 beneficiaries who are there in the foundation. He can decide that 5 will get a higher distribution, 5 will not get a higher distribution, they will get a slightly lower distribution. And he can change that. So that's the flexibility which a foundation will give from a succession plan.
Excellent. Thank you so much, Praveenji. That was very insightful. And we'll move on with such nitty-gritties. But as an overview, because you touched upon some of the salient features of foundation, we would also want to understand when an asset is held in the name of an individual, vis-a-vis a company and vis-a-vis a foundation, what are the major differences in these structures and how a foundation helps much better when it compared to a holding company or individual assets?
Sure. One of the first things that would matter is the question of probate. When the assets are held in the individual name or even through a company. Now, what is the probate? If they are held in an individual's name, if the person were to pass away, then there are two scenarios. One, the person would be having a will, or the person passes away intestate, which is without a will. And we live in this jurisdiction where Sharia is applicable. The laws are applicable based on your nationality also and your religion also. So it adds one layer of complexity to your succession planning. So one of the fundamental things that from a probate perspective, if the person were to pass away, just imagine there's a sole shareholder in a company. Okay? The person has a will. A lot of people think that because I have a will, things will be very smooth. But the probate process takes at least, I would not say at least, generally 6 months. And I have known cases where it's even gone up to 1.5 years. In the interim, what happens to your businesses, operating businesses? What happens to the bank accounts? Will they be frozen? That's the question. So even if you have a will, it cannot provide you enough protection from a smooth intergenerational transfer. That is one difference. From an asset protection perspective, if you are individual, then you've got unlimited liabilities. If you've got any issue, all your assets can be used to pay up or a square of those liabilities. If you have a divorce and a divorce based on the jurisdiction where your marriage has been registered. Okay, there are certain countries, there are certain religions where the marriage is a contract. In certain religions and faiths, it is not a contract. It gets registered. Based on that, how the assets get divided becomes important. There are certain jurisdictions where they recognize prenup, they enter into prenup agreement, so the assets can get divided according to that. From that perspective, it is very important that for an individual, he's got unlimited liability. For a company, even if he's got limited liability, the shares that he's holding in the company are still exposed to the same issues that he gets exposed to when he's holding the asset in his individual name. In the foundation, because he has given the asset, it's owned by a different entity, it's no longer his asset. As long as now one caveat I would like to add is you need to structure it correctly, you need to structure it properly. If you not structure it properly, then the foundation may not give you the adequate protection. You need to go through the legal counsel, advisors, and get your structure correct. Probate I've already discussed. In the case of a foundation, there's no need for a probate because the beneficiaries that are defined in the bylaws and the charter automatically will become entitled to all the assets and the income of the foundation. From a legacy planning perspective, as I was mentioning earlier, you can decide that you're only going to transfer the income and allow the beneficiary to enjoy the income, but we do not have any rights over deciding how the assets get disposed of. From a regulatory regime perspective, the Sharia law is applicable if you're not having a will. Then what happens? I think recently they just come out with an amendment. I think this was in around Feb of last year, where they've defined how the assets will get distributed. It's to the spouse 50%, then to the children. If the children are not there, then to the parents. If they don't have parents, then it will be to the brothers. You as a founder may not want to have that distribution formula. You would want it to go in a particular fashion. So if you do not have a will, or if your will is not well defined, then the existing regulatory regime is going to override. In the case of a foundation, the regulatory regime is very clear, which is common law jurisdiction, DIFC, ADGM, RAC, etc. And you can decide how the actual transfer of assets would happen. From an asset consolidation perspective, let's say you've got multiple properties, you've got 50, 100 properties. Okay. If you have it in your individual name, everything you have to do it at each individual level. The transfer of assets to the next generation would happen at each individual property level. Whereas if it were to be consolidated into a company, it would happen once you transfer the shares of the company, all the assets automatically go to the next generation. In the case of a foundation, the beneficiaries step up, and once they become the qualified beneficiaries, automatically they will get all the rights to that. So from consolidation perspective, it becomes much smoother when you've got a lot of assets across asset classes and a lot of number of units as well. From a flexibility of operation perspective, as an individual, you can pretty much decide what you want to do. You don't have to go through a formal process of a board meeting, a shareholders meeting, or to comply with the law. So that flexibility is available. However, you have to then adjust with a lot of other pitfalls which are there if you have to hold in an individual name. From the UAE corporate tax, I think in the future you are the expert. I would like you to speak on that.
You're talking to me. Yeah.
Yeah, so on a
from-
corporate tax.
Yeah, from the tax perspective, UAE corporate tax fortunately recognizes foundations and similar structures like trust and all as a pass-through structures. What it means by pass-through structures is that, you know, the income will not be considered at the level of the foundation. Income will be considered as directly in the hands of the beneficiaries. So UAE is a very unique jurisdiction at this point of view, wherein there is, you know, there is no personal income tax while there is a corporate tax. So if an income in the hands of corporates get taxed, while the income in the hands of individuals doesn't get taxed. Like for example, a rental income in my personal name, you know, if the property is in my personal name is not subject to corporate tax, while the same rental income, if the property is held in the name of a company, will be subject to corporate tax. So from that point of view, foundation structures like foundation gets a distinctive advantage compared to a corporate or a LLC company or a free zone entity, wherein, you know, all the income that is coming in the hands of foundations, you know, can be subject to no taxation or zero taxation, while in the hands of companies those will be taxable. However, you need to apply for it, you need to, you know, you need to take that exemption separately, but you can certainly, you know, satisfy the conditions and take that exemption on the form if you are having a foundation which is a qualified foundation.
Excellent. So overall, it looks like foundations can be used, you know, if legacy planning has to be kept in mind. From a tax angle, it is beneficial. From an asset consolidation angle, it is if you have assets across the globe, it is a good structure to have. So after understanding these differences, conceptually, we would also want to understand, you know, in a company, trust and a foundation, what are the roles and concepts and what are the conceptual differences when it comes to them? So Pravinji, over to you.
Yeah. So if you look at the roles, pretty much the name would change largely, but pretty much otherwise the roles would largely remain the same. In the case of foundation, it is the owner who is transferring the capital or the asset is called a founder. In the case of a trust, it's called a settler. But the role pretty much remains the same. Somebody who's transferring his assets to create the structure is called a founder or a settler. A shareholder would be providing initial capital. However, there can also be subsequent shareholders also by way of transfer. That's the nuance which is there in the case of a company. Decision makers, because these are all corporate bodies, and there is no individual at top, somebody has to take decision on behalf of this corporate body. So just like you've got board of directors in the case of a company, and you've got a board of trustees in the case of a trust, you would be having council members in the case of a foundation. Now, protection. This is a unique feature which is there in the case of a trust and a foundation. So what does it mean? A lot of time, for various reasons, a professional trust company or a professional services organization or provider would be providing the services of being a trustee. The family may want somebody from the family to act as a protector. If the trustees are not doing their job properly, the protector has the power to replace the board of trustees. The same power is also there in the case of a foundation. A guardian can be appointed. In DIFC, this is optional. It is not necessary or mandatory. You can have an optional guardian, and the guardian's role activates after the founder passes away. As long as the founder is there, if the council members are not acting, the founder has the power to remove them and replace them. After the founder, the guardian can assume that role. The constitution documents are charter and bylaws. The charter is equivalent to a MOA in the case of company. The AOA equivalent in the case of a foundation is bylaws, which is going to define your operations and administration. How will you conduct the council meetings, if you will have veto votes or not, etc. So one important thing is a letter of vision. The letter of vision essentially is a guidebook for the council members to take decisions after the founder has passed away. The founder, through the letter of wishes, will be mentioning what his intention are on how certain things need to be managed. If there's any question which comes up, okay, what is his letter of wishes? A letter of wishes does not have a legal, is not legally binding. It is morally binding upon the trustees and the council members. If the council members think that given the facts and circumstances at that given point in time, if the letter of wishes cannot be administered, there's no problem. So a letter of wishes is not legally enforceable. The ownership of assets would be in the foundation name. In a trust, generally it is held in the trustee's name. Recently, I think around September, October of 2023, they've made a change in the UAE trust law, not in the DIFC trust law, where they've also started to allow the trust to own assets in their individual name. But generally, across jurisdiction in the globe, the trustee would be holding the asset in his individual name for the benefit of the beneficiaries. In the company, as you would know, it's always held in the company's name.
Excellent. So more or less the concept remains the same, and hence, it is easy adaptability for a lot of people who wish to open a foundation. That gives a lot of clarity in terms of foundation setup. But as we dwell into, the nitty-gritties, what are the roles of the founders or the council members and, overall foundation as an overall structure? What are mandatory positions and what are the roles of these bodies? If you can shed a light on that as well.
Yeah. The first and the most important role is that of a founder. A founder is someone who sets up the foundation and who transfers assets into the foundation. A foundation can have multiple founders. One. It can also happen, it is allowed. I don't know practically how much it would be feasible, which is a founder has set up a foundation. A third person can actually also provide assets, can gift assets into the foundation. Just because he has contributed assets, he does not become the founder. He is a contributor of assets, but he is not a founder. A founder is only somebody who sets up the foundation at the initial level and who transfers the assets into the foundation. Once he set it up, he can always transfer additional assets later on. And the founder has a lot of power. He can terminate the foundation, he can withdraw all the assets, he can remove all the council members, he can change the charter, he can change the bylaws. So pretty much he has a lot of flexibility available to him. A council member is charged with administering the assets and the operations of the foundation. At any point of time, just like a company, minimum 2 council members have to be there at any point in time. A founder can also be a council member. Now coming to guardian, as I was mentioning, guardian has the power to replace the council if the council is not doing its job. Guardian cannot be a council member because of conflict of interest, obviously. He assumes significance only after the founder's death. And it's optional. Now, there are 2 types of recipients, the qualified recipients and the deferred recipients. A qualified recipient is a person who is entitled to distribution. It's very important to look at the word distribution. He's not entitled to assets of the foundation. He's entitled to distributions from the foundation. The distribution could be of the income or of the capital accumulated. And if the charter and the bylaws mention that the qualified recipient is entitled to the assets by way of distribution at a certain point in time or upon certain milestone, then he also gets entitled to the assets. A default recipient is in case the foundation terminates for whatever reason, either it has served its objective, or if it has got a finite life, or if a certain event has happened, and if the foundation terminates. And then the default recipient is defined, then the default recipient will be getting all the assets of the foundation. So these are the key roles in a foundation.
Excellent. So now, I would also want to touch upon the burning questions a lot of people generally have, because a lot of international assets are held, people invest in international markets. So a foundation, like you said, probably can get the benefits of DTAA, obviously across the globe. But then there are countries where there are estate taxes, right? So how do we mitigate these things, and what generally a structure of a foundation looks like? If you can quickly cover on the structure bit after the foundation.
Sure. I think before we get into the structure, you asked one more question about estate taxes. I think that is it's a very specific question. It depends on a lot of things: the nationality and the tax domicile of the founder, the nationality and the tax domicile of the beneficiaries, the domicile of the assets, and the respective law of the countries of which is applicable. Okay, where is the jurisdiction from the estate tax perspective? So this is, and it also happens that certain jurisdiction will treat the foundation as a trust or a pass-through structure from the estate tax perspective. So I think that is a very complicated question. We will leave it for another time. I think that itself will take about 2 hours to discuss. Coming to how a foundation comes into play. So you've got a founder. A founder first goes and set up the foundation through DIFC, through a registered agent. Does the name reservation, drafts the first charter, first bylaw, etc. Then he endorses the asset. Endorse is equivalent to settling assets in the case of a trust. It's like a gift in a way, endorse. Once the foundation has been set up, it's an orphan structure. I have not put any arrow on top. A foundation is not owned by any individuals on top. The council is somebody who's managing the day-to-day affairs. The guardian has power over the council, and the distribution will happen to the defined beneficiaries. So underneath the foundation, you can hold assets in various structures. You can choose to hold real estate directly under the foundation. You can choose to own art collectible directly under the foundation. It's very important if you're running an operating business. It's advisable to have a company and not own it directly by the foundation, because as per the DIFC law, a foundation is not allowed to undertake commercial activities. Hence, it is advisable to have a company underneath, and then you can own the operating business. If you want to own the real estate, I will not go into the tax aspect of it. I'm only talking about from a structuring perspective. If it makes sense, you can hold the real estate under a company, and you can also hold a bank account, investment portfolio. It's not. A lot of people think that a foundation can only own UAE assets. Foundation can also own overseas assets. If you're having a stocks and bonds portfolio, if you want to choose, if you want to own, you can choose to own it through the foundation, or you can have a layer of a company and then own through the company.
Excellent. So there is a direct way of owning the assets and investments, and there is an indirect way of owning. Like we said, keeping the estate tax aside, but via company, definitely then it becomes a corporate, and we can avoid a lot of tax structures here. But obviously, thank you so much for this understanding of the foundation structures and how generally it looks like.
Yeah.
And
So I will just interject here. I'll just quickly take, I think I will just have a quick glance at Q&A. I think there are 2 questions which are there. A founder can be the person who's transferring the asset. The founder can be on the council. The founder can also be the beneficiary. However, I would say that it's advisable to make founder one of the beneficiaries along with somebody else. This is from the creditor action perspective. I know if you just look at it as a sham structure, and it can get opened up by the courts. It's better to have somebody else as but a founder can 100% be a beneficiary. There's no challenge to it. The second was, can a council member be a beneficiary? Yes, a council member can also be a beneficiary. Only requirement that is that the council member cannot be a guardian. Thank you. Over to you, Kapil.
Thank you so much. And there are questions, which are very interesting in terms of what assets can be held, UAE properties, international properties, what are the bank accounts, and probably, over to Sheetal sir for a typical understanding on, what and jurisdictions should someone take, because there is DIFC, there is ADGM, there is RAC, right? These are typical 3 structures of a foundation. So more or less they are similar, but I would want to understand what should one keep in mind while selecting a jurisdiction for foundation?
See, as you rightly mentioned, UAE at this point of time, there are three jurisdictions which are offering the foundation structures. It started with a DIFC in 2018. DIFC was the first one who adopted, the foundation structure. And as Praveen clarified that it is coming from civil law jurisdictions as opposed to the common law which DIFC follows. So it is the structure originates from that scheme of jurisdiction, which shows the UAE's adaptability to the changing landscape and the requirements that we have in this country. Followed by DIFC, ADGM also adapted to it, and RAC ICC also came up with this. So one common underlying factor amongst all the three jurisdictions that you can own Dubai real estate through all the three jurisdictions, except from ADGM, you can own Abu Dhabi real estate as well. Apart from that, council members, no physical presence. 2 council members are required in all the jurisdictions. Registered, you don't necessarily need to have an office in DIFC, ADGM, or RAC ICC. All three jurisdictions, you don't need to have an office space. Unlike a company that you register in any of these jurisdictions, you can use registered service provider's office as your registered address. Arbitration provisions apart from DIFC and RAC ICC, ADGM does not have the arbitration provision. DIFC has adopted it. In terms of power of the founders, it is the same lifespan. All of them, it's an often perpetual structure as Praveen described. In DIFC, you can convert a company also to a foundation, which in ADGM you cannot do. So suppose if you have a legal entity, you want to convert that into a foundation, that's a possibility in DIFC and RAC, while in ADGM, you cannot do that. So this is in brief, a distinction between the three and what all these three jurisdictions differ from each other.
Excellent. So talking about, we have briefly covered on the corporate tax angle as well, but, there are cases, or can there be cases where a foundation can be eligible for 9% corporate tax or 15% corporate tax is what we would want to understand, Sheetal.
Yeah, see, foundation has to, across various jurisdictions globally, trust structures and foundation structures are, from a tax perspective, are treated as a pass-through structure, and UAE thankfully taking it from the international tax principles that foundations are being treated as a pass-through structures. However, there are certain conditions that foundations need to meet in order to qualify for this pass-through structure status, which in the law, they have used a word called unincorporated partnership. Those conditions includes one of the primary condition in that is that foundation should not be doing any business. So as Praveen ji also clarified, that foundation can either hold the asset, collect the profits, distribute the profits to the beneficiaries, as long as this is the only activity that the foundation is doing, then it is not considered as a business. And to that extent, it is satisfying these conditions, then it will be treated as a pass-through and hence apply for 0% tax and then take an exemption on it. But apart from that, there is no other condition. Every foundation can apply for it as long as this is all the activities they are doing from a tax perspective.
Excellent. So moving on at least to my last question, and probably, I have seen a few questions relating to that as well. Foundation seems to be a good structure and easy adaptable, but are there any prominent challenges or probably difficulties, I would say not challenges, when you have to incorporate or when you wish to incorporate a foundation? Because opening a company in UAE is easy. Opening a bank account today is very difficult. So is that the same when it comes to foundation, and what are the other nitty-gritties one should remember? Over to you, Sheetalji, and then Praveenji, you can add.
See, and this has been a burning challenge, and that's where, this is such a beautiful structure from a point of view of taxes and also from the point of view of succession planning. The only reason that that we have been holding our horses, and we have been holding our horses in order to advise clients, particularly on setting up a foundation. And from the challenges that we are seeing in the market, is the understanding of the structure from the banker's point of view. I mean, banks here are used to process the usuals, the holding companies, the trading companies, even the trust structures are understood by the banks. This being a relatively new structure and evolving structure, I think getting a bank account is so far, unfortunately, not easy. However, we have seen instances where banks are supporting, certain foreign banks are certainly supporting these structures. And I'm sure UAE banks will also get used to it, and the process time will reduce. Right now, the process time for foundation is relatively much longer compared to a typical company. This is the first fundamental big challenge. Rest is absolutely fine. I mean, in terms of issuing the licenses, there's a set process across all the three jurisdictions. They are issuing the licenses. That is also not a challenge.
Excellent. And any last tips from Praveenji, because you have detailed understanding. So any perspectives or any insights that you would want to talk about?
Sure. I think I'll just continue on the previous thread. So both of you have hit the nail on the head. That is, while the DLD has entered into MOU with DIFC to recognize the land transfers, the banks, unfortunately, I would not say all banks. Okay? So in our case, I would not say that we have yet got the bank account open, but the compliance is at least given the clearance. So that is a good sign. And hopefully, I think, maybe if you were to have this webinar 15-20 days from now, I would hopefully be saying that, yes, we have a bank account which is up and running.
We'll have one more, don't worry.
So that is one. Second is, from a perspective of mortgage, it's not just opening of the bank account. Now, if you're having real estate generally, would want to monetize the assets which you are holding, and you typically do it through equity release or you do it through a mortgage. Now, I am not sure if the banks are very comfortable on that. In our family office, we have not explored that route. And happy to hear from others if anybody has got experience. But from based on whatever I've spoken with people, they are still not very comfortable. They would still insist on a personal guarantee of the founder, etc. Because what you're saying is, how can a foundation, actually do a mortgage? So hopefully the law will also, not the law, it's the practice which is going to evolve, and it is going to, actually be in spirit what the law is wanting it to be. In terms of any other questions, so only one advice is, a foundation it's just like a basic structure. It's just like you have been given the bricks. You can build a house the way that you want to. So it's very important for you to have a conversation with the founder, what his intentions are, and try and incorporate as much as possible. It's not a very easy conversation. Normally, it's not a conversation which you can have in one session or two sessions. It can go over multiple sessions where you try and understand what the founder exactly wants. Sometimes you will be able to understand what his fears and concerns and aspirations are as far as the next generation is concerned. And then try and capture as much as possible into the charter and bylaws. So that is one thing. Second is that, when you're going through this particular jurisdiction with this particular structure, you have to be patient that the other service providers may not be as up to speed on this. Although it's been since 2018 that this has been there, it's only picked up steam in the last 1 year. So I think people are also catching up with them. All the service providers are also catching up with this particular structure.
Excellent. Thank you so much, Praveenji, and thank you so much, Sheetal sir. It has been a real informative panel, and I hope the audience also liked it. But before taking the questions from the audience, I would love to do some poll questions to keep or to understand whether audience got few of the understanding right. So I would quickly run through few questions that we made for the audience, and look forward to taking the questions post that. So if we can launch the poll, probably we can give us 5. I will read the question and then we'll give, yeah. So basically, why are foundations formed? Why are generally foundations formed? Is it to, efficiently plan your taxes, or, succession planning, or both?
Can you show the options here also? Is there a possibility?
Yeah, just.
Or we cannot. Okay, no problem.
So ideally, it is for both. That is succession planning and to plan your your taxes efficiently. But obviously, you need to take care where the assets are and how to transfer or how to structure those things, like Praveenji also mentioned and Sheetal sir mentioned on the structures. It can be another session for 2-3 hours that can keep going, but definitely it's for these benefits. So moving ahead.
Can it show the results of the poll?
Yeah, that is. Karishma?
So the result would come at the end of all the questions.
Okay.
So one by one question people can answer, and then
Can
at
we
the
go to the
end of
second
the
question?
it's automatically coming on the screen of all the audience. So they are able to go to the next questions one by one.
Excellent. I think then we are not able to see it, but yeah.
Yeah, all the audience is able to see it, but panelist is not able to see it.
Okay, so you are getting the answers then.
Yeah.
Excellent.
So all questions. Okay, fine. Can you read the questions, Karishma, if you don't mind, the second question?
Sure, sir. So the second question is, who is the decision maker in a foundation? And the questions are trustee or the council members. Most of the people have answered the answer as council member, and the right answer for the same is council
So
member.
I think the audience was attentive.
Correct.
And then can you just
Yeah,
keep
sure.
going.
Yeah. The third question is about how are family foundations treated for corporate tax purpose. The answer is either it is treated as a holding company or an unincorporated partnerships. Again, the audience was attentive, and the answer being unincorporated partnerships is what 88% of the audience has answered. The next question is, what is the constitution document for foundation? Is it a trust deed letter of wishes, or it's a charter and bylaws letter of wishes, or it's MOA or AOA? Majority of the 93% of the audience has answered the question as charter and bylaws letter of wishes. So that's the correct answer again. Then the next question is, can a founder also be a beneficiary of a foundation? So 98% people have answered it as yes, and 3% have answered as no, but 98% audience giving the right answer is yes.
Excellent.
The next question, what are the principal activities of a foundation? And all the audience have answered 100% as receiving, holding and investing or disbursing the assets, only 0% going to doing business. So of course, as family foundation discussed by a panelist that it cannot conduct the business, the right answer is receiving, holding and investing and assets. And the last question is, does the DIFC Foundation include an arbitration provision? The answer is yes or no, and yes is the correct answer, answered by 93% of the audience mentioning as yes. So these are all the 7 questions, and people have mostly participated and answered all the questions. So once it is being ended, everyone would be able to see the results of the same.
Excellent. Thank you so much, Karishma, and thank you everyone, for answering. So I'll take a few questions before we end the session officially, and we can have Sheetal sir as giving the vote of thanks. But this is for Praveenji and Sheetal sir. There is an attendee who's asked, is it possible to convert a company, an LLC, incorporated in Sharjah, which is 100% owned by members of one Emirati family, into a family foundation?
See, although DIFC has a provision of converting a company to a foundation, but it entails transferring a company from one jurisdiction to another, point number one. And then the first is the portability of the company to DIFC, and then to convert it to a foundation. The first part, I'm not sure. The second part, I'm sure, right? Whether DIFC will port the Sharjah company to DIFC is something that we'll have to check. But if it was a DIFC company, it would have been possible.
Excellent. Can the real estates owned individually across the various Emirates, including the Northern Emirates, be transferred to a foundation established under DIFC? I think this was well covered, but if you want to, just for the clarity, if you want to take it up, Sheetal sir and Praveenji.
I mean, to our understanding, because this country is also very complex, right? I mean, there are 7 Emirates, 50 free zones, right? And they keep on changing the law all the time, right? And that is also, so what we know so far, confirmed from DLD and all, I mean, that Dubai assets can be held by DIFC Foundation, right? When it comes to other Emirates, yeah, I cannot say with surety. I mean, we'll have to go through the land departments of each of these in order to identify. But to our knowledge, there is, it is not the case right now at this point of time.
Correct.
Yeah.
And just
I mean,
to
you
add
have
it up,
also-
because ADGM largely can only do Abu Dhabi. It's like that. So obviously the process is very different. And like you mentioned, 7 Emirates and 50 free zones. So it's always a challenge. But that is one thing for sure. International assets can be held by any of these foundations, and that should not be a challenge.
Yeah, see, the only issue challenge is coming in the registration of the properties. It's nothing to do with, all the shares across the globe, bank accounts across the globe. All of these are possibility. Holding companies across the globe, no problem as far as the foundation registered anywhere. It's just the, real estate bit, which is a, which
Excellent.
the DLD needs. With DLD, the DIFC has an arrangement, but, other jurisdictions yet.
And Praveenji, this can be an insight from you as well. Transferring assets from a founder to foundation, whether the DLD fees of 4% is applicable or is there any subsidized fees?
Okay, very interesting. So if the beneficiaries of the foundation are the lineal descendants of the founder, if they are bloodline family members at 1 degree, then it is treated as a gift with 0.125%. Let's say the properties are owned by the founder in his individual name. He has his brothers who are the beneficiaries in the foundation, then it's going to be 4%.
Excellent.
Very interesting, but
as long as it is treated as a gift, otherwise, let's say if you had a company with the founder as the sole director and the shareholder, not the director, the sole shareholder, and if he was able to gift it to any of his family members at 0.125%, the same rule would be applicable for the foundation. What we need to consider, what we need to determine is, under DLD rule, what is treated as a gifting, the same rules are applicable for the foundation.
Excellent. So moving on to another interesting, I'm taking few interesting questions because unfortunately there are a lot of US related questions which will take, subject to different topics, but related to UAE law and how the foundations work. From Vinayji, there is one question that says, if foundation holds investment portfolios, bank accounts and manages and takes investment related decisions and earn profits out of those, will that count as carrying business activity or still meet the conditions of the foundation?
Sure. Okay. So when I mentioned that the law says that a foundation cannot carry on commercial activities, what it says is there is a caveat which is subject to it being incidental to the main objects of the foundation. Now, if the main objects of the foundation are to hold and manage the assets for the benefit of the beneficiaries, then the activity of investing is not going to be a business activity, because the object of the foundation is to hold the assets and grow the wealth for the benefit of the beneficiaries.
Excellent. Sheetal sir, if you want to add anything, feel free to.
No, the same thing. In fact, foundation. I mean, when you will hold the asset, there'll always be capital appreciation in the asset, and then you book those profits related to capital appreciation. The intention was not to trade in the asset on a day-to-day basis. The intention should be to hold, invest, distribute. Right? That these were if the motive is the main thing, right? And more that is there. But of course, there can be instances where the asset is the motive was to stay invested, but for whatever reasons you had to sell it frequently, and you have to churn the portfolio frequently. That is still a possibility, and can still be considered as holding and distributing the assets rather than doing the business.
Another burning question, can real estate properties in India and stocks of US markets can be transferred to the foundations in UAE?
See, when it comes to property, as I mentioned, it's a difficult question, right? I mean, you have to go to that registering authority in order to find out whether they will register it in this company's name or not and identify, right? But when it comes to portfolio of shares, equities, bonds, securities, whatever, a foundation can certainly have it, in its own name, and hold these assets on behalf of the founders and the beneficiaries.
Praveen ji, if you want to
add to that, right? One is whether the law and the structure allows it. Number one, which is DIFC. Number two is whether the respective countries' jurisdiction, as Sheetal ji was saying, especially in the case of real estate. Three is, why would you do that? Okay, what is your objective? I think we have to go back and ask everything that we do in our family office. Every time we've done any activity, we ask the question, why? Why are we doing it? What is the objective? Can we have another structure which can solve it? Okay, and why should we do it in this particular fashion only? I think that question has to be asked.
So another interesting question, because foundations are a pass-through status, is the income taxable in the hands of beneficiaries, trustees, or founders? So it's a clear understanding that UAE, in a way, personal investments are not taxable, or personal rental incomes are not taxable. So so that way, I think the beneficiaries or the founders should not be ideally taxable if it is a UAE related founder. If it is a global, then it has to take care of the global scenario and probably pay taxes. So any inputs here, Sheetal sir and Pratik?
No, this is very interesting angle that you have highlighted, Pratik, here, right? I mean, see, if I am a tax resident of UAE and I am the beneficiary of one of the foundation, for example, right? Then, because of the unique situation that UAE has today, because there is a reason that UAE, it is still not called income tax law. It is called corporate tax law, correct? Because we are not taxing individuals here. UAE is taxing corporates. So I, being a tax resident of UAE, the income in my hand will be considered is not taxable in UAE because UAE does not have personal income tax. However, if I am a tax resident of any other country and I am receiving the income, the distribution through a foundation being pass-through structure, that particular income will be taxed according to my tax residency and the provision of that particular country where I am the tax resident. So this is very important. This benefit that we enjoy as far as the foundation is concerned is only from the point of view of you being a UAE tax resident or the beneficiaries being the UAE tax resident. If the beneficiaries are tax resident of some other jurisdiction, they'll have to see the provisions of that particular tax jurisdiction in order to identify the taxability of the income that they are getting from foundation.
Excellent. Moving on to a few more questions and relevant ones. Can council member terminate the foundation after the founder's demise?
If the bylaws allow it.
So it's the charter and the bylaws that has to define this. If not, it automatically does not terminate it. Is that understanding correct?
Yes. I'll just double check. I think somewhere I had read this long ago. I think 75% of the council members will take a decision, and if the bylaws allow it, then they can do it.
Correct.
So it is hence it is very important. A lot of people take the standard bylaws and think that this is it. So it is very important to go through each bylaw, sit with the lawyer, advisor, and then modify it.
Correct.
I just want to add here, it is very, very, very good question, in fact. You know, when people open company in UAE, they don't realize the closing of company is equally difficult, right? So this is a very good question from that point of view. Any structure, even if it's a perpetual structure, there should be a provision to be able to close that structure, right? And I think that is what the bylaws needs to address. And then once they have it, you should be able to do it. And without that, it should not be the case, and I would assume that even if it is not in the bylaws, I would expect that, these jurisdictions should allow some way or another, through some special resolutions or unanimous decisions by the council members to do it.
Yeah. So I would just add to that. Let's say you have a stalemate between the council members. You're not able to proceed any further with administering the foundation. Then there's a provision. You can go to the registrar, and then the registrar can take a decision and close down the foundation. But you have to go through the process of going to the registrar.
Yeah. Okay. Perfect. So few more questions before we end. Can an unrelated person not related to the beneficiaries be a founder and or a contributor?
Sorry, I didn't get it.
So can an unrelated person, a third party, be a founder and a contributor of the trust, of the foundation?
There is no restriction as such in the law. So there can be two founders who are not related. Then it would not be a family foundation.
Correct.
But there's no restriction on that. There's no restriction that the qualified recipients also have to be from the same family only. I would say, let's say, for example, just think of it as a foundation which has got philanthropy or charitable objectives. The beneficiaries would be public at large, or would be a subsection which is a defined subsection of the public. They would not be related to each other. They can still be beneficiaries in the foundation. So apart from that, even for a normal foundation which is there, which is not there specifically for a charitable purpose, even there is no restriction as such in the law.
Excellent. So there is a round tripping issue question that I'm avoiding because a lot of Indian nationals want to open. But I think on a larger scale, I'll clarify, if an Indian national is earning global income and then investing in India, it is not round tripping. If the money is inflowing from India and going back, that is round tripping. So I will avoid this question. But last question, how to register a registered agent, and is it mandatory to have a registered agent?
I think, Pratik, you are the best person to answer this.
No, so so in my experience, and I would always say that, registered agent is always a mandatory thing when it comes to DIFC and RAC foundations. And because, that is a place where all the notices or board meetings generally take place. So it is mandatory if it comes to DIFC and RAC for sure. And Praveenji, if you want to add, or Sheetal sir, if you want to add to that.
No, I think I would want to add here, which is important, that you need to take a license for it. Suppose if you want to be a registered agent, then you need to take a CSP license from DIFC in order to be able to do that.
Yeah, not everyone. So I mean, ultimately, you'll have to reach out to a company service provider, and that only can give you the space. So not everyone can get it freely if someone feels that, a registered agent is readily available. So yeah, that ends the question. There is one from Dharmendra ji that says, will personal liability for bank loans also be transferred to foundations? Now, I think, this is a very typical question, but yeah, yes, sir.
Okay.
So
okay, will your banks allow you to have the facility? Yeah, practically.
Correct.
Number one question. So we get to look at what the law allows, and we have to look at practically how it's going to operate. Now, technically, okay, if I were to rephrase this question, if there is a foundation And if the founder has got certain personal assets against which he has given a personal guarantee for another unrelated mortgage or any other bank facility, and if the value of the assets were to drop below the liabilities, can the bank go after the foundation and take the assets from the foundation? No, they can't.
Excellent. So these were the questions, that is from my end when it comes to panel discussion. Over to you, Sheetal sir, for vote of thanks.
Well, I would like to say that this, when it comes to our, I mean, a lot of people that we know, as I mentioned in our introductory remark as well, we get lost into details. We keep on, we get so much busy in our business and we forget to plan what happens after us. And as we know that the two things are certain now, with taxes coming in UAE, it is now proved as well. The death and taxes both are certain. And we should not ignore succession planning, and nor we should ignore optimization when it comes to tax structure is concerned. This is a beautiful structure that that is there in order to make sure there is a right succession planning in place, and right now it is tax efficient as well from a UAE perspective. Of course, there are challenges. I mean, UAE is always, I always say, in UAE, everybody knows something, nobody knows everything, because it's too many things, moving pieces all across. And this is our attempt in order to learn a bit. I have learned from one of the session that I attended on valuation, wherein Ashwath Damodaran said that I have learned everything about valuation while coaching about valuation, right? So it is our attempt to learn ourselves as well. When we do these webinar, we are forced to get into the details. We are forced to, we are more encouraged to invite to experts like Praveen ji, who have gone through a full detail provisions and a process, from a family office perspective. And I would encourage you to share your feedback and share your, any other interesting topics that you feel where, you are finding 5 different answers from 5 different advisors, right? And then we'll try to clarify as much as we can. Of course, we cannot guarantee, there is a full 100% clarity, but certainly this will be a continuous exercise that we continue to do. And thank you for your patience and participating. See you
Thank
soon.
you, Praveen ji, for joining us today, and thank you everyone for staying back patiently.
Thank you for inviting me, and thank you everyone for patiently hearing us.
Thank you.